have been free to come and justify the detention. I would implore you, before you go back to the administrative, pronounce order for release.
You are rushing us. You are rushing us. Can I ask all the journalists to move out?
Ekiri mu kuba kigenda mu maaso obudde buno pulezidenti amaze okuba nga atuuka mu kkooti naye bali mu kugoba abamawulire Dr. Besigye naye butereefu aleeteddwa naye embeera nzibu nnyo kyalimu baganda bange basubu ne bannyabo abali ku ssama e Uganda Dr. eyo ng'olengera embeera gyalimu mbi nnyo. Waliwo breaking news endala gye tugenda batuusaako mu maaso awo pulezidenti tuli naye Joel Ssenyonyi wasa David Lubongoye butereevu omulungi ali kusama Uganda bunkenke bwereere bali mugezaako okuba nga bagoba ab'amawulire munda Kampala biku Dr. embeera gyalimu.
Yes, my big concern and contention is that when you order prison authorities to take them back, now they will be holding them under your order.
And that's why I had wanted the journalists to first leave us, so that we do some housekeeping. Because my friends from Law Society, they are somewhere. So let's unite. Excuse me.
Mukembera bwetyo bwere
Let's move.
We shall overcome. We shall overcome. We shall overcome someday. In my heart, I do believe we shall overcome someday. Seven will die. Seven will die. Seven will die someday. Deep in my heart, I do believe seven will die someday. Both will cry, both will cry, both will cry someday. Deep in my heart, I do believe both will cry someday. And yes, we will live. Best we will live. Best we will live someday. In my heart, I do believe. Best we will live someday. Yes, justice will return. Justice will return someday. Deep in my heart, I do believe
Just feel freedom for all for freedom, freedom for all for freedom, all for freedom, all for freedom, freedom for all for freedom, freedom for all.
Okay, buterefu omulungi ali ku sama Uganda ekyo embeera bweri wano mu kooti Besigye aleetedde mu kooti badde baagala bamawulire kasabaganye okubanga bafuluma ekisenge kya kooti. Dr. Besigye afulumiziddwa mu bukuumi obw'amaanyi ennyo kw'ossa Dr. Abed Lutale naye n'afulumizibwa mu bunkenke obw'amaanyi. Tulinawo breaking news endala egenda okubanga erabikako butono nnyo eriiko simanyi lwaki temusharinga vidiyo mu mbeera erimu egenda mu maaso mu ggwanga obudde buno nga temusobola kubanga musharinga vidiyo ensi nejja neeraba ki ekirimu kubanga kigenda mu maaso. Tulina president Joel Ssenyonyi kw'ossa David Lewis Lubongoye. Tuli mu kooti ejulirwamu wetuli obudde buno baganda bange abasibo ne banyabo nke bw'amaanyi nnyo ddala nga bwekiwulira oba nga bwenyiza okigamba. Abaganda bange basibo ne banyabo mwenna abali ku sama Uganda media. Waliwo breaking news tulina breaking news gye tugenda okubanga tubawa mu budde butono nnyo ku kyekituuseewo ku poliisi kyekituuseewo ku poliisi ey'Ewandegeya tugenda kuba tubibawa masaawo sinza kola breaking news eyo nga si president yagikoze naye nga kooti ewumuddemukko katono nnyo. Kooti ewumuddemu katono nnyo naye ate egenda kuba ekomawo mu budde butono balabe kyekiddako. Dr. Besigye afulumiziddwa mu bukuumi obw'amaanyi. So embeera bwetyo bweri abaganda bange basibo ne banyabo mwenna abali ku mukutu ogwa sama Uganda media to live ku Facebook kwetusinzira okubanga tubaweereza bwetyo embeera bweri mu kubanga ate etambula baganda bange basibo ne banyabo embeera bwetyo bweri mu kubanga etambula. So Dr. afulumiziddwa buli kimu nga madde mukiraba. So ndoza Chairman Enyanzu waliwo breaking news etuuseewo gye tugenda okubanga tubawa naye nga president yagenda okubanga agita. So baganda bange mbasaba mweyongeze kubanga musharinga video n'okubanga mugoberera ensonga nga bwe zirimu okubanga zitambula. Baganda bange basibo ne banyabo. So bwekityo bwe kiri abalungi abaliko. So basaba mwekumize ku mukutu ogwa sama Uganda media. Tulina press conference olwaleero nayo police sigenda kuwa mawulire gakanga for now naye ndowooza president waffe agenda kuba abyogeraku. Bunkenke bukyali bw'amaanyi nnyo wabweru webunguluddwa buli kika kya byakwerinda. Baganda bange basibo ne banyabo wabweru munda mu kooti madala ga kooti mu elevators za kooti na buli kimu bunkenke buli mu kweyongera bweyongezi nga Dr. afulumiziddwamu katono nnyo ne Dr. Abed bafulumiziddwamu katono nnyo. Wetuli obunkenke bukyagendera ddala maaso. Abalamuzi nabo balaga nti bawo bakomyewo. Dr. akomeziddwawo. Mukyala wa Dr. Cheza Besigye katunenya dadi wano dadi obusika mukamabega katono nnyo. Mukyala Dr. Cheza Besigye amaze okubanga atuuka mu kooti windi byanyuma amaze okubanga atuuka mu kooti mukyala wa Dr. Kanokyeza Besigye awene byanyima amaze okubanga abozesa ku president naye amaze gagala kubanga gamuyitamu nakasendeka nnyo gagala kubanga gamuyitamu basebo ne banyabo mbasaba mweyongere okubanga mu sharinga video please. Simanyi okola kyokono nga toyinza kubanga osharinga video. Simanyi kyekyokola ku sofa ekinene nnyo okubigenda mu maaso tulayikenga tosharinga.
Allow me pass. When I will first pass, so that you can get space.
Maama oyo yaddira maama waffe Jole Mugisha mu bigere naye waali okubanga balaba ensonga za retired Dr. Kanokyeza Besigye nga bwe ziri mu kuba nga zigenda mu maaso. Aba FDC n'ebibiina ebyenjawulo bonna weebali okubanga ate tulaba ensonga za retired Dr. Kanokyeza Besigye nga bwe ziri mu kuba nga zigenda mu maaso. Nga bwe mbadde mbanyonnyolako bo obunkenke bususse bo obunkenke busukidde ddala wano ku kooti Abesigye waali banaye temunsindika nnyo esano eno kamera protectinga mukama wange so bane temunsindika eno teva ku Bobi please temuvaako. Chairman Nyanzi breaking news etuuseewo nayo tugenda kuba tugibagamba maaso awo. Chairman Nyanzi all breaking news etuuseewo nayo egenda kuba ebaweebwa mu maaso awo. So bwekityo bwekiri mu kubanga kigenda mu maaso abaganda bange bassebo ne bannyabo Bambega balimu kusetula abasirikale abali mu bantu balimu kusetula abasirikale abali mu bantu nga Bambega balimu kusetula abantu nga Bambega abali mu bantu balimu basitula kooti ekwata omuliro essaawa yonna kooti ekwata omuliro essaawa yonna kooti egenda kuba ekwata omuliro. Banaye bambe tugenda nyo maaso ga president maama tusigala wano bwetutya kamera ne protecting president bambe tamusindika tena weeraga kamera teva ku president Buterevu oli ku Sama Uganda Media beera bwetyo bweri mu kubanga ate etambula wano mu kooti Dr. Kizza Besigye waleeteddwa ne Dr. Abed Lutale bunkenke bw'amaanyi mu kisenge kya kooti kuba omuteeseza baganda bange bassebo ne bannyabo nga bwe mbanyonnyodde emabegaawo nti olwo breaking news etuuseewo ku muganda waffe ssabakunzi wa Uganda ow'ekitiibwa Fred Nyanzi Sentamu so bampita Sama Uganda mwena mawulire wammwe top 10 okubanga mbaweereza ensonga za His Excellency Robert Kyagulanyi Ssentamu era kamera eno eri official okumubeera maaso okubanga bawa ensonga nga bwe zitambula oba okubanga emuprotectinga mu buli mbeera. So bwekityo bwe kiri baganda bange bassebo ne bannyabo mu kisenge kya kooti. Dokita agenda kuba akomezebwawo mu budde butono nnyo. Dokita agenda kuba akomezebwawo mu budde butono nnyo. So tugenda kuba tubawa buli kigenda okuba nga kigenda mu maaso. So okuyingira wano ababuuza security ya president okuyingira wano obadde bunkenke nga bwe mbagambye nti amagye geebongoludde kooti yonna tekibadde kyangu naye tubadde tulinafu okubeerako ku president nga kamera ye eriiso lye erisooka okubanga tuwa ensi ki kyennyini ekirimu kubanga kigenda mu maaso. So yensonga lwaki nti sama Uganda mumulaba wano ne president ne baganda baffe abalala bali mu bitundu ebyenjawulo era ewali amawulire aga National Unity Platform. Ne baganda baffe abalala bali mu bitundu ebyenjawulo ewali amawulire aga National Unity Platform okubanga bagenda kuba babalaga biki ebiri mu kubanga begenda maaso. President kakasa wafulumira wano agenda kuba ababuulira kyekigenda okubanga kiddako. Teyatambudde yekka, yatambudde ne muganda waffe mukama waffe Alop oba leader of opposition owekitiibwa Joel Ssenyonyi. President waffe aliraanye maama oyo mukyala wa Besigye gwe bayita Winnie Byanyima okuli ne secretary general w'ekibiina kyaffe ekya National Unity Platform owekitiibwa David Lewis Lubongoya be batambudde ne president okubanga babeerawo. Bwe ntunula emabegaawo omulungi ali kusama ndabawo eyaliko leader of opposition mu kibiina kya FDC omukyala okuva e Kasese Winnie Kiza naye waali n'abakulembeze ba FDC ab'enjawulo bwe bali NUP. President atugamba ebbanga lyonna nti kyakulabirako y'ensonga lwaki nti ku mbeera egenda maaso president waali mukulembeze tayawulayawula mu bibiina tayawulayawula mu bantu kubanga bannayuganda y'ensonga lwaki nti omulaba waali president waffe omulungi taata essuubi lya Uganda His Excellency Robert Kyagulanyi Ssentamu y'ensonga lwaki nti mumulaba naye waali okubanga buli mbeera egenda maaso abeerawo nga alaba kyekigenda maaso. Tonaku olwaleero era waliwo okusaba njasabiggo ku kitebe kya NUP ebiriwo byonna tugenda kuba tubibawa baganda bange bassebo ne banya mwekumire ku mikutu egy'enkyukakyuka megatta bantu okubanga tumanya ensonga nga bwe zigenda okubanga zigenda maaso. Baganda bange bassebo ne banyabo mbebaza bwebaza mwenna abaliko abatumbudde mu nsi yonna gye musinzira okubanga kwe muli UK mbatumiddeko nnyo America mama waffe Latifa, mutumiddeko nnyo atuyina mu UK mama waffe Madina, mutumiddeko nnyo abaana bali Abu Dhabi abali Dubai abali mu Bahrain nammwe abali Sharjah abali South Africa abali wano e Uganda mwenna mbassamu ekitiibwa mwebale nnyo kubanga mugoberera ensonga z'enkyukakyuka mwebale nnyo okubanga mugoberera ensonga z'ensi yammwe. Kyemukola kya muwendo nnyo kyemukola kya kabi nnyo nkakasa nti mukooye gye muli mwagala kulaba kingi mu ggwanga lino musobole okudda ewaka kyetuliko baganda bange kyetuli mukolako tuyinza ffe okubanga tetuliiwo ne bwe munaaba muzze tubasaba ensi yaffe mugizimbe ku ekyo kyetuli mu kuba nga tulwana baganda bange bassebo ne bannyabo. Tuyinza okuba nga ffe tetuliiwo kubigenda maaso tuyinza okuba nga basajja batugyewo ne bambi tubasaba tufokasinga ennyo ku next generation tufokasinga ennyo ku baana abajja bagenda kubeera mu nsi efaananeta. President ali mu kunyumyamu ne Winnie Byanyima mukyala wa Dr. Kanokyeza Besigye bambi tubasaba bwe tuba tetuliiwo mutuyambe nnyo okubanga muzimba ensi yaffe embeera nga bweri. So bwekityo bwe kiri baganda bange bassebo ne bannyabo eyonda kamera ebeera ku president ono omwami y'omu kubajja bateeka gavumenti ya Museveni ku bunkenke nga ayagala abantu ba bulijjo tebaddamu kubanga bawozesebwa mu kkooti z'amagye era n'asengaawo omusango. So yoyo gulaba ali mu kuhagiga president waffe obudde buno bwennyini. Oyo omwami bamuyita Michael Kabaziguruka era yali omubaka wa palamenti kawa baganda bange abasebo ne bannyabo abali mu kugoberera ensonga nga bwe zirimo kuba ate nga zitambula. Bamwita Michael Kabaziguluka. So bwekityo kiri oli ne top 10 Tata Kisolo Sama Uganda okubanga mbalaga ensonga nga bwe zirimo kuba nga zitambula wano mu kooti. Dr. Kizza Besigye waleeteddwa nga bagambeko emabega awo bataata ne bamaama nti afulumiziddwa mu byokwerinda eby'amaanyi. Embeera gy'alimu nga eragira ddala nti si nnungi, embeera gy'abaddemu ebadde eragira ddala nti si nnungi, naye bamufulumiza mu byokwerinda eby'amaanyi, naye agenda kuba ate nga akomawo, kooti ewumudde mu buwummuzi, naye dokita agenda kuba akomawo. Tulabe ki ekigenda okuba nga kigenda mu maaso. Baganda bange bassebo ne bannyabo, Michael Kabaziguluka ali mu kusaba pulezidenti ku kanamba katono nnyo, ali mu kusaba pulezidenti kanamba era bw'atyo akamuwadde akanamba. So bwekityo kiri baganda bange bassebo ne bannyabo, bwetyo embeera bw'erimu okubanga etambula. Omukutu oli ku Sama, oli ku mukutu ogwa Sama Uganda Media. So bwetyo embeera bw'erimu okubanga etambula baganda bange bassebo ne bannyabo. Kooti ekomyewo. Kooti ekomyewo baganda bange abassebo ne bannyabo. Kooti
unconditional release of Dr. Kizza Besigye together with Bobi, and this is grounded on the provisions of Section 38A, where this honorable court is brought to jurisdiction and powers my lord in situations where the applicants are incarcerated without any lawful orders to my lord grant an order of unconditional release, and this is the provision, my lord, that the High Court may at any time where a person is deprived of his or her personal liberty otherwise than in execution of a lawful sentence or order imposed on that person by a competent court upon complaint made to the High Court by or on behalf of that person. And if it appears by affidavit made in support of the complaint, that there is reasonable ground for the complainant, court is given powers to give award and so on and so forth. The gist of the matter, my lord, is about court being satisfied that the person before court is detained without lawful orders. My lord, these facts are brought out in the affidavit.
Before you proceed, I think the AG was the representative in the court. And he formally be on record. Or if I am seen badly, then you can. The microphones are sensitive. You can speak from there. We have many lawyers, so.
My name is John Foy, I'm a senior state attorney. Together with Matthew, Hesse, state attorney, and Jacqueline Humphrey, state attorney. Your Lordship, we are sorry we are late because this matter was up on us late, and we had to ensure that we respond. We have filed our response.
My lord, on my part, I think 10 minutes is enough, and then my colleagues will also come.
Yeah. It's about
My lord, it's our prayer that we be pleased to find that Dr. Basazeko are a very literate in difficult incarceration, given the fact that my lord, it's not evidence before you that there's any charge further against them, or that there is any man warrant being issued by any court, or any lawful order given by court for the authorities in Louisiana to keep them in custody. My lord, the affidavits which are borne out, the facts which are borne out in the affidavit of the Honorable William Yanima, as well as Counsel Roscoe, are uncontroverted. There is no any evidence of the respondents, that is the Attorney General and the Commissioner General controverting that evidence. And in section 57 of the Prisons Act, my lord, in section 57 is very clear. The Prisons Act can clearly specify the person shall not be received or admitted into prison custody without valid commitment or demand warrant or order of detention, warrant, conviction, or commitment. So that is the law, my lord. And now, my lord, the essence of habeas corpus is well explained in the decision of this honorable court in senior court number 16 of 2021. Honorable Chagulani Sentam Robert, Babula Chagulani Pungo, versus the Attorney General and the Chief of the Defense Forces. On page 14, my lord, a copy of which is going to be supplied to the court. Section page 14, this honorable court had the occasion to succinctly explain the essence of the writ of habeas corpus in the following terms. The purpose for a writ of habeas corpus ad judicatum is to review the legality of the applicant's arrest, imprisonment, and detention, and challenge the authority of the prisoner or jail warden to continue holding the applicant. The application is used when a person is held without charges or is denied due process. Yes. My Lord, that is for the Attorney General and the Commissioner of Prisons to explain by way of evidence. My Lord, I will explain. My Lord, initially there were charges that had been preferred against them as explained in the affidavit of Winnie Nanyima and the Proscopia for the here. My Lord, that is well explained. If I may go there, my Lord, to read the relevant paragraph. The explanation is that, my Lord, the defunct General Court Marshal had preferred charges against them. And on the 31st of January, my Lord, the Supreme Court and the people can pronounce itself for the police.
Aaron Chiza eyali yasibwa mu kooti marshal bwe yalesibwa emyaka 2 naye aleeteddwa mu kooti obudde buno omwami yokubayita Aaron Chiza. Aaron Chiza yoyo naye aleeteddwa mu kooti y'amagye naye yali yamusalira emyaka 2 yenna empingo zimu saze emikono naye aleeteddwa mu kooti.
What happened, my Lord? All the proceedings before the General Court Marshal were quashed by the Constitutional Court, and my Lord, the decree to that effect was extracted. My Lord, I'm sure it's on record, my Lord. Yes, my Lord, we can be granted more time from the table because I don't want to adapt this matter.
We have members of the media. It is very important for them to hear what the Supreme Court says.
My Lord, it is hereby ordered that the declaration of the Constitutional Court that Section 119, subsection 1G, now Section 117G of the UPDF Act, which provides that any person not otherwise subject to military law, who aids or abets a person subject to military law in the commission of a service offense, is unconstitutional. So that order is hereby set aside.
Now, in one line, what is that paragraph?
My Lord, initially the Constitutional Court had held that Section 119, which is now 117, that had provided for a situation where civilians would be subject to military law if they abated the commission of an offense by a serving officer, that was a valid law. they have not nullified those provisions. Now, that order of the Constitutional Court was set aside by the Supreme Court, meaning that Section 117 has now been nullified by the Constitutional Court. All charges, all ongoing criminal trials, all pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with the competent jurisdiction. Three, yes. All charges, my lord, all charges, these charges are preferred by the DPP under Section 100, Article 120 of the Constitution. The charges before the General Court Martial are not sanctioned by the DPP. So the charges to be taken or transferred to the civilian courts pursuant to this particular order are those ones sanctioned by the DPP. As we speak right now, there is none, my lord. There is no charge sanctioned by the DPP to be taken to the civilian court.
So, but in this sense, the decree indicates that there is a certain code, not the civil code, not the civil thing. Is that how I understand it?
That they can, yes, my lord, a court of competent jurisdiction.
So, address us very briefly when I am a court of competent jurisdiction.
In regards to taking fully, this is not a court of competence. But in regards to the matters before you, habeas corpus adis abducienda, we are in the right forum, my lord. Yes. This judgment shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and sentence is being challenged in the court of law. And this is not applicable to the applicants because they are not convicts. And finally, my lord, no, the second last one. All pending trials, all partly hard criminal cases that fall under the civil law court's jurisdiction, which are against members of the UPDF who are subject to service law, must be transferred to the civil courts with competent jurisdiction. It's also not applicable. It's for the serving members of UPDF. 5. Save for the issue of the establishment of the General Court Martial as a court of law, this appeal fails and is hereby dismissed. That is
So, very briefly, how many paragraphs are applicable in the motion before this court?
my lord.
Under that decree?
It is, as far as the matter before you is concerned, it's paragraph 1. It's only paragraph 1 where,
Focus on that.
all right, my lord. My lord, the submission is that following this declaration of pronouncement by the Supreme Court, the proceedings hitherto pending before the General Court Martial under Section 117 of the UPDF Act became inactive. They were quashed, and there are no proceedings pending against their accused persons. And that brings us within the realm of the prerogative order of the writ of habeas corpus. We have already cited Section 57 of the Prisons Act, and also now the Section 38 of the Judicature Act. But now we are addressing you on the issue of curtailment of liberty and the remedy that court is enjoying.
Do you intend to make written submission?
No, my lord, we are given the nature of this matter, my lord, and the circumstances concerning the dire state of our client, particularly Dr. Kizabes, his health status. We deemed it imperative that my lord.
At least I can go on with what was being thrown around the media. There seems to be any order. Okay. For me, I'm really clear that what has been written about status is that one minute, the Lord
3 minutes, my lord. Most of that, my lord. My lord, I've already addressed you on the question of liberty under the authority of Chaplain Captain Tungo. One aspect which I needed to point out in this factor is still on page 14. Liberty is defined by Black Law Dictionary, freedom from arbitrary or undue external restraint, especially by government. And this is, my lord, the import of the spirit of Article 23 of the Constitution, which guarantees liberty of Dr. Basazeko and Bobi Mutare. In this particular case, my lord, under Article 23, first of all, they have not been informed of any offense under which they are, which they may have committed, and the reason why they are in this law, and there is none. Two, my lord, Dr. Basazeko has no access to a personal doctor right now for proper medical examination. And that is a very serious matter, my lord, because in as much as by a cursory look here, court can make one observation that maybe it's improving. My lord, his state, the circumstances compare that an order be issued for Dr. Basazeko to regain his liberty, to be able to access a medical facility of his choice, so that he can be thoroughly examined to assess his health situation and get proper specialized treatment. My lord, the final authority I would like to cite on this one is Tuanka John and others versus the Director General of the Internal Security Organization. It's miscellaneous cause number 9 of 2021, where again this honorable court resolved and decided that a writ of habeas corpus applies in cases of illegal detention, and it's meant to secure the personal liberty of a person under such illegal detention upon determination of the validity of such detention by the court granting the writ. I agree with the counsel for the applicant that preservation of personal liberty is crucial and should only be derogated from in exceptional circumstances where there are court orders, and that is the position of the law. So this particular law, my lord, is reinforced by Section 15 of the Human Rights Enforcement Act. My lord, and this is where we are grounding our prayer. Section 15 of the Human Rights Enforcement Act of 2019.
Maybe to share some information with you, there is a separate application grounded on the enforcement of human rights by a number of lawyers. That filing before another judge.
Most of that. Let me not go there, my lord. Let me sum up, my lord, my submission under Section 30. My lord, it's our humble prayer. Now that the Attorney General and the Commissioner General have not in any way attempted to justify the incarceration of Dr. Basazeko and Bobi Mutare, my lord, you be pleased to order for their unconditional release, and specifically for Dr. Basazeko to be able to access a medical facility of his choice, so that he can be attended to by physicians of his choice.
Make that order now.
Yes, this is the prayer, my lord, that the order be made today and now, under the circumstances. And that's what the writ of habeas corpus is all about. Any continued detention, my lord, would be again further violation. And we wouldn't want to see this honorable court acquiescing in the violation of the rights of the accused person. And one thing I need to emphasize, my lord, is the 48-hour rule, which is very, very crucial and imperative under the Bill of Rights. So you can only curtail one's liberty within that period of only 48 hours. And to date, since 31st, Dr. Basazeko and Bobi Mutare have not been taken any fresh charges whatsoever. So we pray that, my lord, you be pleased to invoke the powers here, grant the prerogative writs, and have Dr. Basazeko and Bobi Mutare released. We do so, my lord.
Like I said, it's my former teacher, so we are trying to be nice.
Hello, maybe just speak. It appears that this reach matter before you
before we even arrive at the decision, I think there are two simple points that must be made. Personal liberty can only be curtailed on the basis of some lawful order. That lawful order cannot be verbal. It must be documented. It must be demonstrable. Otherwise, the curtailment of that liberty is unlawful. And because of that problem, the unlawfulness, that's why we have this written Article 54 as non-derogable. This writ has not always existed. It's the 1967 Constitution. It wasn't there. But from the case of West Vindila was 1966. It was recognized as a common law writ. It then came into the 1967 Constitution thereafter and was maintained into the 95 Constitution. But it has two limits. One has been satisfied. And perhaps the most common one that has been satisfied is that the person has appeared here. But like in Njira's case, it was known where Grace Njira was being kept. It wasn't the case of, the common thing that was sort of disappeared. It was known where it was. Just like it is known where his Africans are. In fact, we need not say much because when they came here, they were in the company of other officers of the state who have a unique attire. So we were able to tell that they are in custody. We knew where they were. So the first thing was that nothing is bring the body. Sometimes we wait whether dead or alive. The body is here alive. Yep. But the second thing, what my landlord has been addressing the court on, the reason for curtailing the liberty of those individuals. My Lord, the Supreme Court did not say that those who are incarcerated should remain incarcerated, except for those who had been convicted. One might have,
for example, I was thinking we needed to consolidate these two applications. So you are saying for our friend Edwin Kisa, since he was convicted, so
that case is actually different, and you will note when it comes up. Those who have been convicted, unless they are not challenging the conviction, I believe my land friend is very vigorous. So there is nowhere in the judgment where it was saying those who are in detention, stay there until such a time that the government decides that to find a competent court and transfer those files. So this application is brought with that idea, my Lord, that argument in mind.
I wish we can get a chair for the AG staff. They need to write some of it. They have to write Supposed to be a lawyer.
Are not among the concerned with the statement. Private lawyer. Not private lawyer. They are your officer.
I apologize. Your officer of the court.
So my lord, one of the orders that was made is that these trials cease and be transferred. In there, they could have had it cease, the detainees remain in custody until the cases are transferred. They did not do so, and they were wise not to do so because they had just pronounced themselves on the illegality of the basis of those charges before the court martial. So, my lord, as we speak, there are no charges pending anywhere in Uganda or elsewhere, apart from a case in Buganda Road on which the first applicant is on bail. His bail is being extended, but he goes back to another location. That is the only one that is pending. But in that one, his liberty was given back to him. My lord, the burden to justify the reason for detention, to curtail the person, is not on the one who is applying. My lord, you can see that the affidavit was not even sworn by the one applying. The burden is not on the one applying. The burden is on the state.
And the state has
The state has implied, I'm going to address what you say. There are two aspects involving the state, two places where the state is in my view. One, the prisons officers would have brought before this court a warrant saying Court X on date Y told us to keep the body of these individuals until we go back. I have not seen it in the response. The second possibility would have been that they are pending charges, and this is the charge sheet. I know those pending charges can't come from the court martial. Because some of the offenses in the UPDS Act can't be tried in the civilian courts. There are offenses there that are very different, with very different character, and they don't exist in the penal code. They can't be tried in these normal civilian courts. So they would have brought a charge which says, you in court X, they are pending charges. This is the reason why these people are. What do they refer to? They refer to the Supreme Court decision, which did not say keep them in court.
maybe it's the edging.
So I want to submit, my lord, and I hope that you will be persuaded that the response from the Attorney General falls short of justifying the reason for denying the applicants their personal liberty. Since the 31st of January 2020, it says nothing to you, my lord, that explains why the liberty is curtailed. It only says the Supreme Court said transfer. But as I have shown you, some of these offenses cannot be transferred. But that may not be a matter for us to address here. But they can't be transferred. So it is our contention, my lord, that a proper case has been laid out by the applicants. This court, which is clothed with that power. Not the power is unfettered. It is so unfettered it can be applied immediately. Clothed with the power to order the release of these applicants today. If the state has a lawful reason, let it act lawfully after those orders are issued. Then deal with the issue, whatever the issue is. Lord, my young friend has made reference to section 15 of the Human Rights Enforcement Act. I am aware, my Lord, you are perfectly familiar with that space, and I very respectfully urge you, my Lord, to find merit in this application and grant the orders that are being sought. My Lord, my land friend, Honorable Sekona, wants to just wrap it up.
How many minutes?
My Lord, I will request for only 2 minutes. Except that I will request that the officer obstructing your view of my body language. You were told that you need to look at me. My Lord, just to sum up, Section 57, which has been cited by my Lord friend, Honorable Elias, is instructive. A prison's officer can only detain on a valid warrant issued by a competent authority, in this case, court. Upon the demise of the General Court Martial, it is very clear that the power of the General Court Martial to order detention collapsed. And it collapsed in the presence of the Attorney General of the Republic of Uganda, who is the first respondent in this application. Whereas it is argued by the first respondent in the affidavit of Mr. George Kalemera, paragraph 9, that the Supreme Court did not order release. There was actually no necessity to order release.
So, yeah, that point.
Yes, my Lord.
So you are trying to bring in some words in the decree.
No, my Lord.
It is saying it was not necessary, but it said so many words.
I am not even wanting to go there. I am only restating the position of the Constitution. Under the Constitution, liberty is guaranteed. Restriction must be justified, and that justification must be a lawful one. And in this particular case, the lawfulness would only be cemented on an order, on a valid order of a court with competent jurisdiction. In the absence of it, there is no justification, and it is your power, my Lord,